Okay, welcome back, and we'll proceed with the last case on the docket, Sungate versus Citigroup.
May it please the Court.
May proceed.
Thank you. Good afternoon, Your Honors. Brock McLean, representing the appellants in this case. I would like to reserve 4 minutes for rebuttal.
Okay.
Your Honor, I'm going to, this is a fairly involved case. Our briefs are longer, thanks to the grace of the Court, than the allotted page limit. And so I think maybe a short encapsulation of the facts would be helpful. The appellants, my clients, are limited partners in a limited partnership that was at the critical time controlled by the Appellee, and it was part of a Appellee's fiduciary line of business.
When you say controlled by the Appellee, are you talking about the highest level Citigroup, or
yes,
are you talking about any of their subsidiaries? There's
no dispute, Your Honor, that Citigroup had a line of wholly owned subsidiaries, and that ultimately, yes, at the highest level, Citigroup Inc., the Appellee, was the controller of those subsidiaries, absolute owner and controller.
Okay. I'm with you.
There's not
controlled it by virtue of the fact that they owned various and sundry levels of subsidiary corporations.
There's not a dispute as to the fact that they own and control the subsidiaries. They're also controlled, as has been alleged in our briefs, through appointing agents in those subsidiaries, and that is the manner by which Citigroup runs its business. The Appellee runs its business, and agency, actually, I was going to get to it in a minute, but agency is an important element of the lower court's finding. The lower court held as a matter of law that agency was not an issue in this case, and had not been found as a matter of law. And we have substantial evidence of agency that that was in discovery that was presented to the court below, and I'm happy to point that out to the court. The principal argument demonstrating a lot of the evidence of agency you can find on page 6 of the initial brief, page 6, footnote 6. And this just gives you an idea of the evidence of agency that is present in this case. So that when we say control, we both mean that it's undisputed that they were the 100% owner, but also that they control through agents that are layered into their lines of business. And when I say lines of business, I'm not necessarily referring to entities. Part of this case is the manner in which Appellee runs its business is irrespective, really, of a corporate chain. There are corporations. The corporations are created for convenience, but the executives in those subsidiaries report directly to Citigroup, to Citigroup's chief executive officer or other officers.
What's the impact of the relatively lengthy conflict of interest provision that's in the private placement memo of the feeder fund?
Well, the impact in terms of the lower court's order was substantial. I believe the lower court quoted it at length, and the lower court, I believe, relied on that largely in making its ruling. The conflict of interest language that is about 3 or 4 pages long essentially states at one point that, and I can get a quote of it, but essentially, you can read it, it states that the limited partners waive claims arising out of the existence of conflicts of interest. That phrase, that sentence is in there. Then it proceeds to come up with lots of examples of potential conflicts of interest. So your question is, what is the impact of it? Well, the impact, according to the lower court judge, Judge Munyon, was very significant because she relied on it in her order. But let's take a look at that phrase, that 3-page disclosure that she relied on. Also in the private placement memorandum you will find on page Roman numeral 5, towards the beginning of that private placement memorandum, you will find a paragraph under the heading Reliance. And hey, I'd like to quote from it just a second. The first paragraph begins with this memorandum, this PPM, which is unsigned but is incorporated by reference by the subscription agreement. Memorandum is qualified in its entirety by reference to the limited partnership agreement and subscription documents. It goes on to end, only representations and warranties contained in these subscription documents and the limited partnership agreement shall have any legal effect. Only those two documents, and it's contrasting that with the document in which that statement is contained. There, Your Honor, I would submit that reading the 3 pages of disclosures in conjunction with that sentence, the court should conclude that the waiver language, the disclosures, are of no legal effect.
Well, I thought the signature page of the subscription agreement had language in it that says investor acknowledges that she's read and agreed to the terms of a number of things, one of which is the confidential private placement memo.
That's right. They acknowledge that, and then it says, I think it says it's incorporated by reference, but maybe, or words to that effect. And, Your Honor, what they read and what's incorporated by reference is a document that states on its face that it's of no legal effect. So how does the court reconcile that? Does the court disregard it and not mention it in its order? Is that the correct way to deal with a contradiction within the document like that? Or is it correct to say, well, it says it's of no legal effect, let's give it its plain meaning? Or is it an ambiguity, which means we would want to submit it to the jury? The one seminal case in Delaware, we don't dispute that Delaware law governs this case, is the Werner case. You've seen it cited in the materials. The Delaware Chancery case, 2003. The Werner case found where there was an ambiguity in that particular case that the court held that where they're citing another Delaware case, that I believe it's page 23, that when evaluating an ambiguity in a limited partnership agreement, such an ambiguity should be resolved in favor of the limited partners. That's the statement of the Delaware Chancery Court. If we have an ambiguity here, this court can decide it based on Delaware law in favor of the limited partners. This court can decide it on its face, that statement nullifies and cancels the disclosure language, or this court can simply say, we consider it to be a fact issue because ambiguities are fact issues, and we're going to let that go to the jury. In any case, that warrants dismissal. Continuing on the subject of that disclosure language, and the Werner case, and there's another case after Werner, which was argued extensively at the oral argument below, so it was placed before the court. The Werner case says many things besides the fact that ambiguities are resolved in favor of the limited partner. The Werner case also stands for the proposition, which is quoted again in the Forsyth case cited to the court, that boilerplate disclosures are ineffective. The disclosure pages of this document of the PPM starting on page 30 could be in any limited partnership agreement or private placement memorandum. There's nothing to tailor that language to this document, and that is not an issue really in dispute. We've in the record looked at other similar disclosure paragraphs.
In Werner, didn't the court say in that particular situation, way at the end of that decision, that excuse me, the disclosures did not have enough specificity? In this case, you have disclosures, do you not, that actually described what happened here, in that you had a Citigroup subsidiary advising the sellers, EMI. You had a Citigroup subsidiary, Citibank, doing the lending. And in fact, in the disclosures, did it not say that Citigroup subsidiaries may be involved in lending, Citigroup subsidiaries may be advising businesses that are selling that may be adverse to your situation, meaning the investor situation?
May I grab the case?
Sure.
Your Honor, I believe yes, that language, of course, is part of the disclosure language. I would submit to the court that notwithstanding that disclosure language, the language, number one, is not specific enough to let the limited partners know what was going to happen and the risks to which their money was going to be put. This case is not merely a conflict of interest case, and just because the appellee completely disregarded the issue of conflicts of interest, and it had a waiver in here related to conflicts of interest, but so it played four different roles in this particular the EMI acquisition, one of which was to be our general partner. That disclosure still lacked the critical specificity, which was to let the limited partners truly know that the propriety and worth of what the appellee was going to allow to be done with their property. The footnote, the last footnote of...
Before we leave that point, I'm looking at the moment, I'm looking at page 18 of their motion for summary judgment, and what they contend there is, and I'll read it. It says, the documents creating the underlying partnership and the feeder fund made clear that CAI and CPE have no ability to control how invested funds are used. This authority is granted exclusively to the general partner of the underlying partnership, a company called Terra Firma Investments 3 Limited. So I guess what I'm trying to understand is whether or not you think that's an accurate statement or not, and if not, why not. Their contention is that none of the city organizations, wherever they happen to be in the food chain, had the ability to tell the feeder fund or the underlying partnership how to invest their money. And so if they invested it in EMI, which they obviously did, and made a bad call on it, that was their bad call, essentially, and not based upon anything that was told to them or should have been disclosed to them. So tell me why that isn't an accurate statement if you disagree with it.
Judge, may I finish that answer?
I apologize.
Or, no, I will definitely answer your question, but this is just one little minor, actually a significant point, I think. Going back to the Werner case, the last footnote in that case actually is a quote of the PPM that was at issue in that case. And in that PPM, it describes that the principals are stockholders, directors, and officers, and receive compensation in respect to services provided to other entities. By virtue of their influence over the management of the partnership, these individuals are therefore subject to conflict of interest. And it goes on to say that the executives will be executives with portfolio companies. And in that case, what happened was the executives or the general partner's controlling owner allowed an investment into, or directed an investment of portfolio money into a company that then entered into a consulting agreement with another company that those people had an interest in. It's pretty much the conduct that's described in that disclaimer, but that they were going to do that, it describes generally a conflict of interest. But here's, I think, a very significant point that Werner is making. It's that Werner says, even if the PPM were considered, it would not suffice to obviate Werner's duty of loyalty claim because the defendants submit that Werner acknowledged the potential for conflict when he received the PPM, and that acknowledgement of potential conflict precludes a subsequent complaint. It says, the PPM, however, did not disclose the potential conflicts with enough specificity to prevent Werner from bringing a duty of loyalty claim, and ultimately it states, it cannot be said here that the boilerplate disclosures convey full knowledge of all the facts. Indeed, the language in the PPM does not contain any disclosure that the general partner would cause enterprise portfolio companies to enter into lucrative consulting agreements with AnswerThink. That's the degree of specificity that is required in Delaware, and Forsyth has a very similar description in its circumstance. And so the point, I think, to be taken away is there's a difference between disclosing conflicts of interest and waiving one's duty of of fiduciary duty. This doesn't,
That gets back to Judge Orfinger's question. CAI and CPE, they were not directing the investments in the funds, were they not?
Well, here's an interesting situation. We have a fund that's a feeder fund, so there is a relationship with the terra firma fund, which is the fund that is handling most of the limited partnerships investment. However, within the limited partnership, there is a general partner, and the general partner is the Citigroup subsidiary. The limited partners, notwithstanding their relationship with terra firma, had a fiduciary relationship with their limited partner, their general partner of their partnership. The general partner and the general partner's controlling owner didn't have a difficult job to do, but the job that they did have was not to allow or cause their subsidiaries to enter into transactions inimical, and I'm quoting here, inimical to the limited partner's interest of the limited partnership they were a party to. They needed, if this is all about Deutsche Bank didn't owe us a fiduciary duty. Citigroup did. And the Refco case, which is cited as supplemental authority, states at page 20 that in that case, as the general partner would breach its duty of loyalty if it purposely caused one of CIH's wholly owned subsidiaries to act in a manner inimical to the interests of CIH, or knowingly failed to stop the subsidiary from pursuing such course of action. So yes, we also had a limited partnership relationship with terra firma, but that doesn't affect whether Citigroup had the ability to stop the transaction with EMI that occurred, and they did, and there's substantial evidence of that. That transaction had to be approved at the highest level of Citigroup. Ian Cockrell's testimony cited in the materials. A committee convened before the deal was done. They knew that it was a bad investment. They called it terminally ill. We know that. It was such a bad investment that they, in order to make it a little better, they exacted another $250 million out of the equity side, limited partners, before it closed. These are all acts of Citigroup and its agents. As I said, the CEO and COO, that level needed to approve that. That's in the testimony.
Needed to approve the financing with Citibank. What else were they involved in? Or
If they hadn't approved the financing, the deal would not have gone forward. So it was a but-for causation moment for them, and that's a moment when they know there are multiple hats that they're wearing, and they're deciding, notwithstanding those hats.
I'm still trying to get a clear understanding in my mind of who had the ability to make the decision on behalf of the feeder fund and the partnership over how the money would be invested. Wasn't that terra firma?
Terra firma was the equity side of the transaction, but the transaction wouldn't have happened without Citigroup's active involvement, without Citi and its subsidiaries' active involvement. And so they were at this.
And that's assuming that no one else would have loaned on the deal. I mean, if some other bank would have come in on, and as it turned out, obviously it wasn't one of their better loans.
I think the evidence in this case would indicate that this was a deal that was being put together very, very hastily, and that at the time it was coming together, they didn't have many options.
At the end of the day, who made the decision? Who had the legal ability to make the decision that for the partnership and the feeder fund, this is where we're going to put our money? Was it terra firma, or was it Citigroup or one of their subsidiaries? Well,
Citigroup was advising the seller, and Citigroup was putting the deal together.
Right. I understand what they were doing on the seller side. I'm trying to focus on what they're doing on the buyer's side.
Well, on the buyer's side, they were obviously.
So were they saying nothing, or were they saying, you guys go, this is a great deal and you need to get in, or did they just say nothing? Who made the call, this is where we're going to put our money, under the documents? Who made the decision for the partnership or the feeder fund, this is what we're going to buy? We're going to buy EMI.
Within the underlying partnership, that wouldn't have involved Citigroup directly. But Citigroup knew what the transaction was, had a duty to us as limited partners, and had the ability to stop the transaction.
So help me understand understand this.
Okay.
And I don't want to put words in your mouth. You concede, if I understand what you told me, that Citigroup and their subsidiaries did not have the ability to say buy this or not buy it, make a binding decision. That was terra firma or someone else.
Yes, terra firma they could have decided not to do the transaction.
Is it your argument, though, that the breach of duty was that they or one of their subsidiaries knew that this was a bad deal, a terminally bad deal, and because of the relationships that existed, they had some legal obligation to disclose that to terra firma and the feeder fund that this is a bad deal, don't do it?
Whether they had a legal obligation to disclose it to they could have disclosed it to, they didn't have a fiduciary relationship with the partnership above the feeder fund, but they did with us. And they needed to either disclose and get our permission, that would have been one way to cause us to take the responsibility, or they needed to avoid doing it, as the Refco case suggests, that they can't cause their subsidiaries to.
And your contention is that the disclosures and disclaimers and waivers that they have in the documents that we referenced earlier aren't sufficient enough to do that prospectively.
That's correct, and nor are they specific enough. The waivers that are in there merely talk about potential conflicts of interest, and what we're talking about is a self-interested deal to the detriment of the limited partners, which is something more than a conflict. It's not just a conflict. Just like a lawyer, if I were to get two clients together and say, I need you to waive a conflict of interest, they can waive it, and then they can't sue me merely because I had a conflict of interest. But is there any question that if I then took information from one client and used it against the client that waived the conflict to their detriment, that I would be liable for that? I'd still be liable because I'm still a fiduciary, but they've waived the conflict fact.
Okay, you've gone over your time.
Okay.
You wanted to reserve 4 minutes. I'll give you a couple extra minutes, and I'll give you some extra time as well. So,
Thank you, Judge.
Good afternoon. May it please the Court, Your Honors. Andrew Ehrlich from Paul Weiss, Rifkin, Wharton, and Garrison on behalf of the Appellee in this action, Citigroup, Inc. We respectfully submit that the summary judgment entered below by Judge Munyon should be affirmed in all respects. First, on the ground that by signing the governing documents for this transaction, the LPA and the subscription agreement, the investors, the appellants here, waived the claims they assert in this case.
How do you respond to his argument that there's some ambiguity or that the waiver document says it can't be relied on? I forget exactly how he put it.
Sure.
I'm sure you remember better than I do.
Yes, Judge Orfinger. I think if you look at the paragraph, and it's page Little Roman 5 of the PPM, it's page 1565 of the appellate record, and you read the paragraph that Mr. McLean cited in full, what the paragraph says very clearly is this is an informational document. It is a summary of the terms. You should look to, it provides a series of terms. You should look to the LPA and the subscription agreement as the binding documents, and that those, to the extent there's any inconsistency between the PPM and the documents that they sign, those are the binding documents. So then we go and we look at those documents. And as I believe you pointed out in questioning Mr. McLean, those binding documents, the LPA says very clearly that the investors read and understood the PPM, and in particular, it actually pulls out two sections. It identifies two sections that it asks the investors to represent and warrant that they read, understood, and agree to. The risk factors for the transaction and the potential conflicts of interest. So far from burying the information about potential conflicts, it asks, the transaction documents ask the investors to sign and specifically warrant that they read those particular sections. So I don't think that the paragraph Mr. McLean cites in any way vitiates the effectiveness of the PPM when in fact the appellants here signed documents saying they agreed to be bound by it. Since we're talking about the waivers, if I might also address Mr. McLean's discussion of the Werner case, I think the passage you pointed out, Judge Maltz, actually is directly on point here, because there, in Werner, there were two issues. One was that the these directors entered into a self-dealing contract, a consulting arrangement, with an entity that was a related party. And they rely on very general disclaimer language, which is found in footnote 67 at the very end of the opinion, which basically says that some of the affiliates of the general partner have other relationships for which they get compensated. But I think what Werner really makes clear is the contrast between the disclosures here and the disclosures there. Let me focus briefly on the disclosures. The PPM starts with a general disclosure, which says that Citigroup, and this is on page 1599 of the record, and its affiliates, subsidiaries, engage with lots of different businesses: underwriting, insurance, banking, asset management, and so on and so forth. And in the future, there may be some conflicts of interest. And there are then 3 full pages of specific scenarios that could arise. This is not mere boilerplate, as Judge Munyon found below. So for instance, there are 2 relevant potential conflicts that are cited by Mr. McLean, by appellants in this case. The first is that a Citigroup Inc. subsidiary, Citigroup Global Markets Limited, or what we call CGML, which is a UK-based investment bank, financial advisor, was one of 3 banks, actually not the lead bank. Greenhill was the lead bank, and Deutsche Bank and CGML were subsidiary advisors to EMI as EMI went to sell itself because it was a troubled company and it was looking for a buyer. That was expressly disclosed in a section entitled Conflicting Representations of Buyers and Sellers at page 1600 of the record, which disclosed that if a Citigroup Inc. subsidiary acted as advisor to a business that Terra Firma was looking to buy, there could be conflicts of interest, and critically, and this is a specific part, with respect to the negotiation of the purchase price. That is exactly what the appellants here are complaining of, that by virtue of CGML advising EMI as the target, it was obviously negotiating with Terra Firma, trying to get a better price for EMI. Terra Firma wanted a lower price. So that's exactly the scenario that's identified in the risk disclosures. The second issue that comes up here is that a different Citigroup Inc. subsidiary, Citibank NA, an incorporated Fed-regulated national banking association, helped finance the acquisition of EMI by Terra Firma. The transaction was structured as a leveraged buyout. Terra Firma invested equity and then financed the rest of the transaction, roughly $5 billion worth, with financing. And Citibank provided that financing. That also was disclosed specifically in the risk disclosures. In a section entitled Commercial and Investment Banking Relationships, the PPM disclosed that a Citigroup Inc. subsidiary could, quote, provide credit facilities to Terra Firma which provide specific rights and obligations on Citigroup, close quote, and that in carrying out those rights and obligations, the Citigroup Inc. subsidiary's interest might not be aligned with those of the feeder fund investors. And this is again the specificity here, including Citibank holding a security interest senior to that of Terra Firma. And again, that is exactly what the appellants here complain of, that ultimately when the deal, when Terra Firma couldn't service the debt, Citibank NA held an interest senior to the equity holders. So that, again, was specifically disclosed, and as Judge Munyon found below, this clear contractual language, which by virtue of signing the subscription agreement and LPA was adopted and agreed to by the limited partners, serves to waive all of these claims. So going back to Werner,
let's assume that we're impressed with or moved by the waivers as Judge Munyon was. Does the waiver of conflicts equate to in instances where there's a fiduciary duty, does that waive then the requirement of candor or disclosure if some of those entities, I think there's so many different ones here, I think it was CAE or CIE that were involved, even though they may not have a conflict that would prevent the deal from being done, do they have a duty of disclosure that would require them to say, look, we're involved in this, and, you can't stop us because we've got this waiver, but we know this isn't a real good deal, and we are under an obligation to tell you that because we've got this fiduciary duty. Is there a fiduciary duty with any of the Citigroup subsidiaries, and it looks like specifically it might be Citi, CPE, or CAI?
That's correct, Judge Orfinger, and we don't dispute. CPE was the general partner of the feeder fund. CAI was the administrator of the feeder fund, and we don't dispute that there is a fiduciary duty that would run from those entities to these plaintiffs.
The question is it your view, though, that ends there at that corporation, and they didn't have any duty to seek out further information, or?
Correct, Your Honor. I don't believe we're not aware of any authority that would suggest under Delaware law that those general partner entities were under an obligation to go investigate the activities of unrelated corporations like Citibank NA or CGML. But even, so we're not aware of any duty. And in any event, the evidence in the case, I believe, is undisputed that the individuals who were involved in the feeder fund at CPE and CAI were totally unaware of the activities of CGML in London, advising EMI, or the Citibank NA bankers, mostly in London, advising terra firma. And in fact, the testimony is undisputed that the people at CPE and CAI, because as I believe your question suggested earlier to Mr. McLean, the ultimate decision as to what to invest was made by terra firma. And so the folks at CPE and CAI, the record is undisputed, didn't know that terra firma was going to buy EMI till it was announced. They had no involvement in the transaction whatsoever. Their role was effectively a ministerial one, which was to send out capital call notices to the limited partners when, in fact, terra firma asked them to. And to infer a breach of fiduciary duty here, Your Honor, and if I may, let me turn to the fiduciary duty issues, because the appellants don't really contend that there's a fiduciary duty here in the sense that's commonly understood under Delaware law, which is that there is a direct relationship of confidence and trust where one party reposes confidence and trust in another and the other accepts that confidence and trust. The record is uniform here that the investors, the appellants, had no contact even with Citigroup Inc., who is the only defendant in the case at all. That is undisputed. No contact, not an email, not a phone call, not a letter, nothing. Their contact was with Smith Barney, a brokerage entity that's not a defendant here, and their contact was with CPE, which sent out the statements and the capital call notices and all of that. So what they really urge is a very different, unconventional kind of fiduciary duty, and which has no basis in the case law that we know it. So even though there are clearly fiduciary duties with CPE and CAI, what the appellants urge is that those somehow get imputed up the corporate chain to Citigroup Inc., and then not only up the corporate chain to Citigroup Inc., which is the defendant, but then down one branch of this corporate chain to Citibank NA through a variety of subsidiaries, and down another branch of the corporate chain to CGML, which was advising EMI. And again, we are frankly unaware of any law in Delaware or any other jurisdiction supporting this theory. Fiduciary duties are circumscribed. They're narrow. They're the exception. They're not the rule. They are not generated willy-nilly all over a corporate tree with entities that are not aware of the plaintiffs and don't even know of the existence of the feeder fund. To be clear, the record here is undisputed that the folks at Citibank NA who were working out the terms of a loan to terra firma did not know that this feeder fund existed until, candidly, my law firm called them because they had to provide information for the lawsuit. And similarly, at CGML, The same was true until this lawsuit was filed and information was requested of CGML, which advised EMI. They were totally unaware of the existence of the feeder fund. So what is the proffered basis that appellants give for this sort of fiduciary duty that climbs like a vine all over the corporate tree? The basis is basically the Wallace line of cases, the so-called Wallace line of cases in Delaware. And those cases really don't help. Wallace is a 1999 Delaware Chancery Court opinion, which actually stands for the proposition, if you read it, that the default rule is that fiduciary duties are contained to the subsidiary that has the actual fiduciary duty with the counterparty, and that a subsidiary fiduciary duty does not typically bind the parent, absent two exceptions. The first is that the subsidiary is a sham, and I don't think anybody here is contending that CPE or CAI are shams. They were legitimate entities. CAI was an LLC with an LLC agreement. It had a board of managers, it had a CEO, a CFO, a general counsel, its own financial statements, and so forth. And Mr. McLean makes much, the appellants make much of the fact that there are reporting relationships that exist. For instance, there's testimony in the record that CAI had its own chief risk officer who reported to the head of CAI, but also to the chief risk officer of Citigroup, Inc. That's unsurprising in a large, diversified, multinational company that there would be some centralization of function like general counsel, like HR, like risk, and so on. That does not make the subsidiaries a sham. It does not permit a plaintiff to pierce the corporate veil and impute fiduciary duties from a subsidiary up multiple levels to the parent holding company and then back down to other subsidiaries. And to be clear, because there have been repeated statements, and we heard it just again today from the appellant, that Citigroup, Inc. controlled the feeder fund. Now, and that's undisputed. That is very much disputed, Your Honor, and I think if you look at what Judge Munyon held below, and I think the record before you supports, it shows that that CAI and CPE had a normal arm's-length subsidiary relationship from the parent. They were not controlled in the way that the Wallace line of cases suggests, because what the Wallace line of cases suggest is that a parent can be bound by the acts of the fiduciary duties of a subsidiary where the parent controls and makes use of the partnership property. That's the key language from Wallace. So the question is, did Citigroup, Inc. here control and make use of the partnership property? And there's simply no evidence in the record for that, and I would point the court to page 13 of our brief. Footnote 6 contains the record citations. All of the key protagonists here from CAI were deposed in this case. And the testimony is undisputed. I'll give you one example, and this is the record cite on page 13. This is Blair Jacobson, the key person in the transaction on the CPE side. Have you ever been an employee of Citigroup, Inc.? Answer, no. Have you ever been an officer of Citigroup, Inc.? Answer, no. As far as you're aware, have you ever been authorized to act in any way for Citigroup, Inc.? No. I believe you testified that earlier from approximately 2001 to 2010 you worked for CAI. Is that correct? Yes. Okay, during your time there, in your experience on a day-to-day basis, did Citigroup, Inc. direct the affairs of CAI? Answer, not that I was aware of. And the testimony is the same from each and every other person who worked on this transaction. There is simply no evidence of Citigroup, Inc., any officer of Citigroup, Inc., doing anything in connection with the feeder fund. Indeed, Mr. McLean deposed the former CEO of Citigroup, Chuck Prince, who testified that he was only vaguely aware of CAI's business. It was an extremely small part of the overall corporation, and certainly had never heard of the feeder fund. There's simply, as I said, no evidence of direct control of the partnership assets. Your Honor, briefly on agency, I must confess I don't totally follow exactly what the appellant's argument is with respect to agency. Mr. McLean suggested earlier that Citigroup appointed agents with respect to this transaction. I believe the testimony I just cited, and that's in the record, and indeed is uniform, that nobody at Citigroup Inc. instructed anyone at CPE or CAI to do anything. And indeed, at page 18 of the Appellee's reply brief, they say that the limited partners have never contended that Citigroup should be charged with a fiduciary duty to the limited partners merely because Citigroup appointed agents. So I think what that agency argument boils down to, again, is basically this Wallace argument that somehow under this line of cases in Delaware, not applicable here, if a parent directs the actions of a subsidiary directly and controls the property of a partnership, it can be, fiduciary duties can be imputed upwards. And to be clear, and finally on this fiduciary duty point, the evidence is the same with respect to the other elements of Citigroup Inc., the other subsidiaries. The senior lending officer at Citibank NA, Ian Cockrell, was deposed in this matter, and he testified he never worked for Citigroup Inc., he always worked for Citibank NA, and was never authorized to act on behalf of Citigroup Inc. And to be clear, Citigroup Inc. never authorized anything with respect to this transaction. Mr. McLean is very focused on a meeting, and it's a curious name, called the Wise Men Committee. And I don't know who the wise man, how you get to be a wise man, but in any event, if you look at page 48 and 49 of our brief, what happens in this circumstance, the Wise Men Committee convened on important policy issues for the bank. And that group got together in the summer of 2007 as the transaction was coming to a close, because typically under the London Stock Exchange rules, where a public company is taken private, in the contract, 90% of the public shareholders have to tender their shares. Here, they had gotten to 75%, and typically banks waived the 75%, waived the 90% requirement and agreed to 75%. And the question was, in this case, should Citi do that? And the reason it was an important question was in the intervening time between the time the deal was signed and closed, the credit crisis started, and the credit markets became dislocated, and the economy was rapidly changing. And there was a question of, should we engage in this waiver? Well, they never had to reach a decision because EMI got to the 90%. So nobody at Citigroup Inc. had to approve anything, waive anything, or do anything. The credit was approved, the record is undisputed, and again, the citations are at 48 and 49 of the brief on this, by Citibank. The CEO of Citigroup did not approve anything. The COO of Citigroup did not approve anything. It was entirely contained within Citibank NA. Your Honors, I see my time is up. If you have any further questions, I'm happy to address them.
A couple extra minutes if you want it, because I told opposing counsel he could have a couple extra minutes since he kind of went over his time, but it's up to you, whatever you want to do.
If the court has any further questions, I'm happy to address them. Otherwise, I'm happy to rest on the briefs for the rest of the arguments.
Okay, thank you.
Thank you.
Well, I've got it set for 1:51, but in any event, I'll give you a couple extra minutes.
How long, Your Honor? Oh, minute 54. Thank you. Your Honors were concerned about whether terra firma should have received a disclosure. Your Honor, I believe it's in public record that terra firma thought it should have received more disclosure because terra firma actually has filed a lawsuit for fraud against Citigroup relating to this very transaction. So that may indicate what they think about that issue.
Counsel for the Appellees acknowledged, and I don't think there's any dispute, that there was a fiduciary relationship between CAI and CPE with the plaintiffs or the appellants. What is your contention that creates the fiduciary relationship between Citigroup and the appellants?
Well, as counsel for the appellee correctly says, the Wallace line of cases very, very clearly imposes a duty on a controlling general partner on the controller of the general partner, not just on the general partner.
How does Citigroup control CAI and CPE if they didn't even know or hardly knew it existed?
Well, I don't believe that they knew it existed. I mean, you're just talking about Chuck Prince there, but for one example, there is a document in the record, unfortunately I don't have it at my fingertips, but that is the internal document for CAI and CPE to determine how they can spend proprietary money, and there are different levels of approval that they need within CAI and CPE to spend different amounts of money. Above $250 million, that requires the approval of the CEO of Citigroup, Chuck Prince. They are directly in communication and are directly aligned with that's an extraordinary relationship. That's not simply appoint the board of directors. They're actively involved in making decisions of how they spend money. I'd be happy to supplement the record with that, but I believe it is in the record.
CAI and CPE were not making the decisions on how to spend the money when it came to EMI. They just gave a pot of money to Terra Firma, and Terra Firma made that decision, correct?
Your Honor, I was just speaking to the general control issue. Internally, they did have control and direct control in that sense over the company. Your Honors, I would point you to the Forsyth case. The Forsyth case specifically states, again in an example akin to the Werner case, that where there was not a disclosure to the limited partners of the propriety and worth of the investment that the general partners made, or the owners of the general partners were making in that case, that had a self-dealing element, they said, even though it was a very specific disclosure, it wasn't enough. So here, these limited partners had no knowledge of the propriety or worth of what was going to happen to their money. The Forsyth and Werner cases were not mentioned at all in the lower court's order. It's the controlling Delaware law on whether a waiver has occurred in a circumstance of a limited...
Wrap it up real quick because you're out of time.
I certainly will, Your Honor. Your Honor, I think I would conclude by just advising the court of what we are seeking here. And we believe that it is straightforward that there's a finding of waiver that is the main point of the lower court's decision, and whether you're looking at the internal language of the documents, or you're simply looking at the fact that this is that the language does not say that it breaches fiduciary duties, and certainly doesn't disclose the high standard under Delaware law. This court can make a determination that there was no waiver.
Okay, we'll look at that and see. Thank you.
Thank you, Your Honor.
Thank you.
Thank you all. Have a safe trip home.